Good morning. Welcome, everyone. I believe, Doc, this is the right time to bring you on board as the head of NDPC, which is partnering with us to have this event to bring in your opening remarks. Thank you.
Thank you very much. Good afternoon, Nigeria. Good afternoon to everyone on this call. Let me start by really appreciating the Africa Digital Rights Hub and Meta for partnering with us to generate this masterclass, which is still part of the Privacy Week, which we started last week. The privacy ecosystem globally requires experts globally community human power to drive whatever we are doing in the area of privacy in our different countries. And if we are not really strategic about developing the requisite human capital, we'll be lacking behind in whatever is happening at the global space in the area of data privacy. And that is why we are putting it together in collaboration with Meta and Africa Digital Rights Hub. That yes, we have a model in Nigeria that is working for us. There's a PPP model of licensed DPCOs. And even for what we have in the law, that each data controller or processor in the country must designate a DPO. What knowledge of data protection impact assessment do they really have? I mean, practical knowledge in this case. And we discovered that through some of the annual filing audits submitted to us, we are still not there yet with some organizations. Some are doing very well. But recall that we started at different stages, and yes, there are bound to be gaps. In an attempt to bridge such gaps and ensure that we're on the same page, especially in the area of DPIA, which is a very important component of data privacy and protection. That is why we are putting this together to build the capacity of our data protection officers in different organizations, data controllers, data protection, and even for our data protection compliance organizations that are really carrying out compliance service to different organizations. And we believe with all of us working together, we'll be able to achieve a very robust data privacy ecosystem in Nigeria. In Nigeria, as part of what we are contributing to the ecosystem, we just started our national certification process, that is certification of data protection officers in country. Instead of writing for exams, we have instituted a process in Nigeria for the training and certification of data protection officers. And DPIA is one of the major components of the modules that were put in place for this training. So I enjoy all of us that on this call that are participating in this masterclass today to take this seriously. No knowledge is lost, and nobody knows it all. Even if you're an expert, I'm sure with the quality of resource that we have, we're able to at least gain one thing or the other, which to a large extent, I believe, will support in whatever you are doing your different organizations. Even as a regulator and the commission, some of our staff have also joined to further strengthen our capacity in the area of DPI. And some of us also, I would advise that we take something away from here, that we should make it a train-the-trainer program. Some of us that are acquiring this knowledge, when you get back to your different organizations, please try to bring together your team and share knowledge with them. That is the only way we can really grow in this country. And I implore all of you to see it as something that is very serious. I'm sure if you are to pay, we will pay heavily for this kind of training. And for African Digital Rights Hub and Meta to put this together for us, I think it's really commendable. We promise that we're going to work with you to deliver a very robust data privacy in Nigeria. So welcome you all for being part of this. And we thank you all for joining. Thank you very much.
Thank you so much, Doc, for allowing us to do this. And I believe you've already said that. So my name is Teki Akuetteh. I'm the Executive Director for the Africa Digital Rights Hub. And like Doc rightly said, we're doing this as part of the Data Privacy Week. And it's also part of our capacity building activities. And we're doing it in collaboration with Meta. I, at this point, want to bring in Dr. Shyllon to also, bring some initial remarks, and then we can start.
Thank you so much, Teki. Good. So it's afternoon for me, but I guess it's probably morning in other places. I don't want to belabor the point. Just want to, thank the ADHR as well as the NDPC for collaborating with us on this initiative. As we always say, data protection is very important to us at Meta, and also Nigeria is important to us as a country at Meta. And so for us, it's really our pleasure to be involved and to collaborate with the NDPC as well as ADHR today. And looking forward to an engaging next 3 hours on the very important topic of DPIA. I think I'll leave it there for now. Thank you very much, Teki.
All right, thank you so much, Dr. Shyllon. And once again, welcome everyone. Just a few housekeeping duties and then we will start. We probably may be spending maybe a few hours here, but the idea of this masterclass is supposed to make sure that the training is engaging. And so we'll spend the first hour running through some workshop, explaining to you some of the key processes, methods, or things that you need to know about DPIA. And I will be doing this with Dr. Shyllon, after which we will take a break, a 10-minute bathroom break. And then we will move into what we call our breakout sessions. You would see on your screen the breakout rooms are to your left. At that point, we'll come in and give instructions on what you need to do and how to go about it. So without much ado, I will right away start the training. And you will realize that at the bottom of your screens as well, we have the Q&A. So as the training is going on, you can quickly use the quick Q&A if you have any questions. And also so that we make up on time, because there are more than 200 of us here. We are hoping the number would jump because we had about 300 plus registrations. Kindly introduce yourselves in the chat and where you're coming from, so that we are able to get to know you. I'm hoping that you may be able to use a similar approach in the chat so that we can save up on time as well. So thank you once again for joining. I will start sharing my screen, and then the training can start right away. I believe you can see my screen, right? Okay, so the name of this masterclass is a data protection impact assessment. I believe a lot of us have heard a lot about data protection impact assessment. And so it's not new to us, but the objective this morning is to talk a bit more about it and then help you at the end of the day. Our objective is that by the time you leave this training, you should at least be able to know what a data protection impact assessment is and how you can conduct one. So at least at the very basic level, you should be able to put in place or conduct a data protection impact assessment when necessary. So a data protection impact assessment is essentially a process to evaluate potential harm or risk to an individual by a new system, a new product, a process which involves the use of personal data. It assesses the processing, its necessity, its proportionality, and helps to manage the risks to individuals' personal data. And I believe it is important to note that DPIAs are not necessarily mandatory for every processing operation. They are not, and I will repeat that, they are not mandatory for every processing operation. It's required when the processing is likely to result in high risk to the rights and the freedoms of natural persons. So when there is a likelihood that the risk, there's like the likelihood of a high risk to the personal data that is going to be processed, then you trigger a data protection impact assessment. It is also a process for demonstrating or building compliance. So one way of demonstrating that you're trying to comply with the data protection laws with a number of regulators is also the ability to show that provide your data protection impact assessment report as well. Now, I remember that I had already said that it is linked, you only trigger it when there is a high risk. So what I want to talk about here is what are some of those high risk activities, right, that can trigger. Now, when you're using sensitive data, and what is sensitive data? We know that under the laws, there are different types of data. There's the ordinary personal data and sensitive data. And I will be speaking across many jurisdictions, even though I know that we're looking at Nigeria specific, just to give you a broad knowledge around here. But usually sensitive data involves high-level information that the law has designated as sensitive. It normally includes the, data related to health, data related to children or vulnerable groups. And by data, what I mean is personal data related to particular type of activities that ordinarily you would not want to make available, except under restricted circumstances to perform specific acts to you. So whenever you are going to use sensitive information, let me just give an example. Assuming that you are a hospital that is conducting, let's say, some research into new medicine, and you may want to run clinical trials on maybe HIV medicine or medication. And by that, it means that you're going to collect certain information about HIV patients, right? This is health record. It may be their name, where they live, their diet, and other sensitive information about them. Then it is a high-risk activity, and these are some of the activities that a regulator would typically say, look, you need to look into conducting a data protection impact assessment. Also, when you're looking at automated processing, and by automated processing or automated decision-making, this can happen in a situation where let's say, by way of example, you've put in maybe an HR system, right? And the HR system, I'm talking about an electronic system or a computing system that is responsible for maybe examining the performances of employees, after which it will then determine, so the system will do the evaluation and determine who should be promoted, who should not, who should get salary increment, who should not, and the like, so that there is very limited human intervention in the decision-making process. That is also an area that is considered high risk for purposes of DPIA. And it is also an area that usually, if you're undertaking these activities, regulators tend to say that conduct a DPIA. Now, systemic monitoring. So assuming that, let's say that as government in this day or an age of smart cities, we're putting out cameras on our streets for monitoring or for traffic regulation, for security, other forms of security regulation and all of that. These are activities, or you even decide that, okay, you're going to be monitoring telephone or online activities for purposes of cybersecurity and all of that. Those kind of monitoring activities may lead to some form of covert surveillance, and they are high-risk activities that can violate personal data of individuals, for which reason it is important to conduct an impact assessment as well. In this day and age of AI, when you're looking at large-scale data processing, so you're collecting huge amounts of data from different sources and you're bringing them together to make informed decisions, maybe about products, about services, about marketing for businesses and all of that. Any form of high-scale data processing is also a trigger for a data protection impact assessment. I already mentioned this when I started. When you're looking at sensitive data as well, it's closely linked to vulnerable groups. And so in situations where, let's say, you're looking at particular groups of people, for those of you who may know in the past, for instance, this is one of the reasons that out of which Kenya's data protection law was passed, especially because of people in the border towns and the fact that the processing of their information for national ID could trigger discrimination and the like, which ended up in the Kenyan courts and the Supreme Court taking a decision to say that, look, government has to implement or put in place a data protection law to ensure that these vulnerable groups, as far as collection of their information for identity is concerned, should be protected as well. So whenever there's any form of collection or processing of personal data of vulnerable groups, it could be people with disabilities, it could be people with particular ailments, it could be people of a particular ethnicity, then we need to think of it as a high-risk activity, and we need to look into how processing is being done. And usually regulators will require that data protection impact assessment is done. Also, when you're looking at an innovative technology, so in today's day and age with AI and several other emerging technologies coming up, sometimes with these technologies, we haven't thoroughly looked at its impact on the processing of personal data. And it's known, especially today, that a number of these engagements involve processing of high level and sometimes even sensitive personal data as well. So it is also, when you are looking at developing new technologies or innovating with new technologies and the like, it's a high-risk activity that should trigger a DPIA. Now, if you're thinking about a new way to use personal data, an innovative way to use personal data, something that is not normally done as well, it's the time and place to think about a data protection impact assessment. Usually also when you're transferring to countries, transferring data from your country to countries without adequate protection of data. And most of the laws that we have across Africa talks about transferring to either adequate countries that have the same or higher levels of protection than the respective country from which you're transferring the data to. But most of the time when you're transferring data to other countries that either the regulator has not designated as adequate, then it is important to also conduct a DPIA. We consider it as a high-risk activity, which should trigger a DPIA. Also, when the processing may interfere with individual rights. So a good example would be surveillance, would be, where it will limit people's access to particular things that they are guaranteed as fundamental rights. Then it would also lead to triggering a data protection impact assessment. So these are some of the steps in conducting a DPI. And at this point, I just want to say that we do not have usually, to effectively run this training, you may have to do it over a number of days, and it can take a lot of time to get people to really understand. But we have a few hours here, so we're going to try our very best to get you to understand. But that is to say that there are a lot of online resources that are available. We will also point you to some of the good ones that are out there to actually help you effectively think about a DPIA and conduct a DPIA as well. But these are some basic steps that we have identified as key to conducting a DPIA. Remember the very first thing I said is that a DPIA is not for every activity, every personal data processing activity. So the first step that you need to take is to decide whether or not DPIA is appropriate, right? So assuming that you are an organization that is undertaking a new project that involves the processing of personal data. If it involves, let's say, a new system, you as an organization, you are bringing on a new system, you are changing particular processes by which you operate your organization, anything that you're doing that involves personal data, at that beginning, you want to decide, is it appropriate or is it not? And to decide whether or not it is appropriate, you may have to go back to the slide that I just came with to look at whether it forms part of the high risk activities, for you to decide whether or not the DPIA is appropriate. Now, when you decide that, assuming that, let's say, as a retail company, right, online retail company, we decide that we're going to use AI for processing customers' information and all of that, it may be a new way of doing things as an AI company, online, an AI e-commerce company. But bringing on board this new innovative technology, i.e. AI, to help us with the processing may be a new step that we are taking. So at that point, the question would be, okay, maybe the processing itself as an online entity that just sells their wares to clients and probably do manual processing of this data may not necessarily trigger a DPIA. However, the moment they say that maybe they want to engage Llama to help them do that, or they want to engage any other, let's say an AI system to help them with the processing of that data, first of all, there's innovative technology involved. It may be, secondly, there may be the need to share personal data with these technologies to enable them perform effectively. Thirdly, the technology may be combining this data with other sets of data to enable it work efficiently as well. All these are high-risk activities that will trigger a DPIA. So assuming that we decide that for the online company, look, there are the new processing that we want to involve AI in is a high-risk activity, then we move to the next step. And I must say that there are very well situations where after the first stage, your answer may be no. And so there is no need for a DPIA, as I had mentioned earlier. So once you move to the next step, after you've determined that a DPIA is appropriate, then you have to describe what processing you are doing, right? So you need to know what kind of personal data is going to be involved, how I'm going to be using it, and the like. And I'll share more information on this as we go along. Our third stage will then be to describe the scope of the processing as well that is involved. So first, what kind of processing am I going to be doing? Am I going to be processing sensitive data or ordinary personal data? What is it going to entail? Then after that, I look at what are the purposes for which I am processing. Remember, all these questions are to lead you to answering questions that are also linked to data protection, right? As to whether the purposes are legitimate or not and all of that. Each of these steps can sometimes lead us to say no or yes, but in the end, that is what you're seeking to achieve with the data protection impact assessment, is to see whether what you're doing with the information respects the law, protects the individuals, and if it doesn't, then maybe put in place other steps or totally stop the processing of the information because it puts individuals at a very high risk if you cannot mitigate the measures. Now, once you describe the processing, you look at the scope of the processing, you determine what purposes that you're processing the information, personal data for, you then move into what we call stakeholder consultations. And I'll share a bit more information about that. Now, at the stakeholder consultations, what you need to do is identify your key stakeholders within the scope of the processing, right? These key stakeholders could be individuals whose data will be processed. It could be staff that will be responsible for processing. It could be technology service provider that would be responsible also for the processing activities as well. Now, after you engage your stakeholders, you want to look at access. You want to assess the necessity or proportionality of the processing in accordance with the law, right? So am I collecting over there? You're asking yourself questions that typically comes with data protection, which is, am I collecting only minimal information that is needed? Am I using it for the specific purpose for which I'm collecting it? Is the information that I'm collecting proportional to the processing that I need to do? And like I said, these are all steps to help you mitigate any risks that you may have as an organization or entity. From determining what is necessary and what is proportional, you then move to identifying the risk. I spoke a bit about what are some of the risks that are involved, and I will spend a bit more time on this particular training to emphasize the importance of identifying the risk, and I'll share with you some of the risks as well. Now, when you identify the risk, you want to look at what are the mitigation processes, right? So assuming that the risk of, let's say, collecting this information or surveillance information for a smart city, the risk is that it can likely lead to covert surveillance. What are the mitigation measures that I'm going to put in place? How am I going to determine that the people who access the information have the right legal requirements and backgrounds to access the information and the like? Now, when you identify the risk mitigation measures or processes, you then move into an action plan, right? The action plan talks about what you need to do, the risk mitigation methods, and a plan to put in place or implement the risk mitigation measures that you've identified. It could be access control, it could be procedures that require third parties that may have to access information to ensure that they have the right legal authorization to access the information. It could be ensuring that there's a third-party contractual arrangement to ensure the security of the data as it transits to the third parties and all of that. Of course, after all of these, you want to review, and we call this a post-implementation measure. So the idea is to have a review process that first of all says whether or not, my actions or my implementations are mitigating the risks that I identified. And as I always tell people, data protection is a continuing activity, right? So you don't want to conduct your DPIA and just go to sleep. What you want to do is every now and then have a process that allows you to come back and make sure that everything is working as you identified it and as you programmed for it to work. So these are issues that I call trigger criteria, and it is also linked to what I initially spoke about, which is identifying the risks. So these are some of the risks or harms that should help you trigger a DPIA. I had already mentioned some in the earlier ones, but this probably goes into a lot more detail. And as I mentioned, there's a lot of focus on this training on the risk because we believe that it is the risk that actually trigger a DPIA. And so people need to identify what the risk is in order to be able to know when or not to conduct a DPIA. So the first I had mentioned innovative technologies, right? That will process high level of personal data that may involve bringing or linking together other data sets from other sources. You want to think about that. I spoke about automated decision-making, which is quite straightforward. Any program or system that is monitoring personal data or individuals of any sort, any process that will put in place denial of a particular service to an individual as well is a trigger criteria for you. Any special category data processing activity. So when I say special category, I'm also referring to sensitive data category processing activity, health records, maybe designated health records, children's data, vulnerable people's data, and other lawfully designated special category data processing activity as well. It could even be linked to some level of national security activities as well. Any high skill profiling engagement. So the high skill profiling usually involves a huge amount of data collection, which I mentioned at the beginning. And so that also will be a trigger for you. If you're processing biometrics, that is a trigger to conduct a DPIA on that activity or processing. If you're processing genetic data, remember genetic data is sensitive data under our laws or special category data, and that should trigger a DPIA. When you are data matching, right? So assuming that you want to take one information from one source and then take it to another, maybe you're collecting, let me just use Facebook, information of Facebook people, and you want to match it to general information that you pick on Google or on Amazon or any other network or LinkedIn or any other network. So you're going to match that data. Even if you're doing it manually or electronically, then it is a match, you're matching one personal data to another. There's a high risk involved there because there's a high risk that you may mismatch, you may, it may likely lead to profiling, wrong profiling of someone, and that should trigger a data protection impact assessment. If you're doing invisible processing, and by invisible processing, we mean a processing situation where the personal data or the data subject is unlikely to know that this processing is going to happen. So it may be happening on their blind side, right? And they have no way of knowing that you are collecting or using this personal data. That's also a trigger criteria for a DPIA because of the risks that come with processing of that personal data. Also, if you're looking at tracking through maybe geolocation processes, behavioral processes, anything that makes you monitor, an individual, either from their location, from their behavior, or attributes or a particular way, then that should also trigger. When you're targeting information on children and vulnerable groups as well, it is a trigger criteria. And when there's a risk of physical harm, and that physical harm, we are looking at health and safety of individuals, that should also trigger a DPIA. So here are some more examples of the risks and harms, right? I mentioned this in passing, but surveillance, anything that may involve any form of surveillance, covert or otherwise, it should be a trigger for a DPIA. Anything that involves inappropriate collection of personal data. And by inappropriate collection, I mean you're collecting something that is not necessary, something that is irrelevant for the purpose for which you want to process the data. It should trigger a DPIA. Is a harm or a risk that you need to pay close attention to. Identification. So you're identifying people as groups or special groups or associations as well. When you're aggregating data on individuals from multiple sources, I just spoke about this. You're looking at secondary uses of the data or non-obvious follow-up uses, right? That is a DPIA trigger. When you're excluding somebody from a service or opportunity, so you decide that, okay, you're using a particular process to eliminate people from accessing, let's say, free healthcare, free education, or you're using it to determine whether or not they are due for promotion or otherwise, that should also be a risk or harm that can trigger a DPIA. Of course, when there are security, something that could lead to security breaches, right? Including unauthorized disclosure of individuals' data or breach of confidentiality, that is also a risk of harm. Distortion or unauthorized alteration of that data. I was earlier speaking about matching, right? So when the matching is likely to lead to a distortion or alter the information about the person, then it's a high-risk activity that you need to conduct a DPI on. When it's going to expose individual to harm such as fraud, bullying, identity theft, extortion, that is an example of a risk of harm. And so forth and so on, because we have limited time, but we are going to make these slides available so you have opportunity to go through them as well. So how do you clearly conduct a DPIA? How do you get a DPIA right? You have to first, as an entity, stipulate DPIAs clearly in your policies. So your data protection policy should stipulate, one, as an organization, when to conduct DPIAs, what are the trigger situations within an organization that will bring out, that will make you conduct a DPIA. And this must be clearly stipulated in your key policies within the organization. These policies could be IT, it could be HR, it could be so many, any of the other policies that you have. It could also be very well centered in your data protection policy as well. Now, you need to ensure that your data protection impact assessment is implemented alongside your project planning and development processes. So here, I'm not just talking about policy. I'm talking about when you're stipulating it within your policy, for instance, your procurement team or your new product or services team, or even your, let's say your IT team should know that anytime we're buying a new software, anytime we're issuing a new product or service, right, that involves A, B, C, or D set of information, then we need to conduct a DPIA. And it must be well noted as an organization within your planning and development processes for projects, for services, and so that, you know, it's a natural thing for people to know and be aware of it. Because the biggest challenge you have is that maybe you're launching as an organization a new product or a new service that involves a high-risk activity. And because the project or product team is different, right, from the data protection team, and there is no oversight around when DPIA must be conducted and all of that, there's likely to be a problem where the product or service is brought out before you as the data protection team identifies the risk associated with it. You need to also look at have a data protection impact assessment policy. And what the policy does is that it defines clearly when you, as an organization, will trigger a data protection impact assessment, what are the risk areas, what are the key, let's say, departments or roles that will be responsible for having that, and so forth and so on. Now, you need to also have a DPIA screening checklist, and I'll talk to you more about this screening checklist as well. You can only get your data protection impact assessment right when you do your consultations. As I mentioned, first you need to identify your stakeholders and have comprehensive consultations with them around the process as well. You have to do a lot of training around the DPIA, especially with staff that are not necessarily data protection minded, right? I've mentioned the likes of procurement, IT, let's say a product team or new services team or marketing team and all of that. They need to really understand when should a DPIA be triggered and who should be conducted. And you need to conduct comprehensive training to actually enable you do that. Now, you have to ensure that data protection is integrated as part of your organizational processes. And this is directly linked to the first point, which is that it must be clearly stipulated in key policies within the organization so that everybody within the organization knows that as soon as this is happening, they can bring it to the attention of the, let's say, the data protection team that, oh, we are doing this. It looks like there's a high risk. Can you take a look at it to see whether or not we need a DPIA as well? There has to be a reporting component to it. So even the processes to determine whether or not a DPIA is needed. The reporting is also critical, especially when you want to demonstrate to regulators that you're actually doing the right thing as well. And you need to have a process for reviews, right, of these. So the reviews is going to take into consideration your, let's say, high-level corporate or entity DPIA process, as well as specific DPIAs that have been conducted, and ensuring that these DPIAs are meeting the objective for which they were determined. Now, this is a very simple DPIA screening criteria that we've suggested here. But like I said, we would point you, there's so many tools that are out there that you can use, right? And this is based on some of the things that I had shared earlier. So there are a number of categories that you want to look at. I spoke about nature of processing, right? Does the processing involve large-scale data collection? Is the data processed for a purpose different from which it was originally collected? Will the data be shared with third parties or transferred internally? And you can go on and on and on and ask so many questions around the processing in the light of the risks that your particular organizations have. You also need to look at the categories of data. So you need to have questions around what kind of personal data is being processed at this point and all of that. And a screening criteria like this for any organization can easily help you. You can train different staff departments actually on it so that they can easily raise this and, you know, do a quick check to determine at any point in time whether or not a DPIA is needed and draw the appropriate entities or roles that will be responsible for the DPIA as well. You need to talk about data subjects and scale. And this is looking at, okay, what number of data subjects will be involved? Does the processing monitor behavior? Does it track? Does it profile? Are data subjects in the position to easily opt out as well? You want to look at the purpose and intent for the processing, which would involve things like, is it likely to have significant impact on their rights and freedoms? Will it involve monitoring? Could the processing result in discrimination, financial loss, reputational harm, and the like? You want to look at what technologies am I using, right? Is it AI? Is it machine learning? Is there another form of automated decision-making involved? Does the processing involve complex flows or extensive integration with other systems? Is the technology used untested or under development? All those would raise risks, you know, that should trigger that. And then you need to look at the security safeguards that have been in place. Is that anonymization, studio anonymization? Have you put in place adequate organizational or security measures? Is there what are the legal and regulatory contexts under which you're operating, right? Is the processing explicitly required by law or particular regulations? Are there uncertainties about compliance with your data protection laws? Has there been has it been subject to prior consultation with the supervisory authority? So other regulators that may be involved. These regulators could be maybe an IT regulator, it could be data protection regulator, it could be a banking authorization regulator and the like. You want to look at rights. How does this affect individuals' rights under the data protection law, for instance, their rights of access, erasure? If there exists the right to be forgotten, you need to think about that as well. Will the processing involve automated decision-making with legal or significantly or similarly significant effects as well? Then you have to look at your data retention and deletion policies as well. Now, if any of your answers, right, remember that you're doing some initial screening to these. So you've determined that it's a high risk area. After you looked at the high risk, you decide to do the DPIA screening to determine whether or not DPIA is required, is necessary. If you end up marking yes to one or more, then DPIA is likely to be required. It's likely. It may not be. You may have to take some other steps and come to the conclusion that it's not necessary. But usually, if you go through this screening criteria and you define it properly, and there's a yes answer, then there's a likelihood that DPIA will be required. So this is a sample DPIA template from the ICO. Is one of the very useful tools that you can look at to see how a DPIA will be conducted. I think I would like to bring Dr. Shyllon in at this point to speak to the industry perspective around DPIAs, and then we'll come back.
Thank you very much, Teki. So I don't have slides. I'm just going to speak very quickly to my notes. So I think just to give an overview of what I'm going to talk about, is to, first of all, start off with explaining where the responsibility lies within Meta for DPIAs. And then I'll talk a little bit about what does the NDPA say in particular about DPIAs in terms of how they should be run, and then compare that with global best practice. Also leveraging the guidelines have been shared, or the the documents or the work of the ICO, which, as Teki already mentioned, are very, very useful. And then talk about, like very quickly, how we go about DPIAs at Meta, and then conclude. So just to kick us off, I mean, within Meta, we have the Office of the Data Protection Officer that supports the DPO herself. She's female. This is for Meta Platforms Inc. And they essentially support the work of the DPO in fulfilling her obligations. And there are two main pillars that this falls under. This is in respect of accountability and also in terms of oversight. So in terms of accountability, it's really about being accountable to data protection authorities, for example, like the NDPC in the case of Nigeria, and to data subjects in particular. And there are main areas, of this accountability. So this includes being able to sort of show that you're implementing a comprehensive privacy compliance program, creating and maintaining numerous documents, one of which, of course, is DPIA, advising around compliance with privacy laws globally, sort of interfacing with regulators as and when necessary, and of course, being like a POC for data subject rights as well. In terms of oversight, it's important, as you can imagine, that the DPO and our DPO does have the powers and the rights, the type of access levels and the type of support that is required to enable a DPO fulfill their role, right? And also be able to delegate that power. Because as you can imagine, in a big company in particular, the DPO is only one person that cannot do every single task related to the role, even including DPIA. So there should be a way of delegating these powers. Of course, there will be a system of monitoring as well. So that, in a nutshell, is how it's the responsibility for this within Meta. To speak very quickly, and of course we have folks from the NDPC in the room, and probably can do a better job of this, but wanted to just run through what the Data Protection Act says around DPIAs. Again, it reiterates what Teki has been emphasizing around, this being required only where there's high risks. And it's really about identifying the risks and the impact of the processing of personal data. And so what is required is that, it consists of a systematic description of the processing that is anticipated, the purpose of that processing, even if it's also the legal basis on is legitimate interest, and also, what the involvement of the data process and also of third parties. Secondly, it also assesses the necessity and proportionality of the processing in relation to the purpose of the processing. Third, it assesses the risks and the rights and freedoms of data subjects. So risks on one hand, and then the rights of the data subjects. And finally, it's about measuring, how the risks that you are sort of highlighting can be addressed. What are the safeguards? What are the security measures that have been put in place to ensure that personal data is protected? I think this pretty much, aligns with what Teki has shared, and with what the ICO has also said about in terms of steps for a DPIA. So it's really about identifying the need for a DPIA, describing the processing, consultation, assessing necessity and proportionality, identifying and assessing the risks, identifying the measures that you're taking to mitigate the risks, and of course the sign-off and the outcomes need to be recorded as well. Just a few things I wanted to highlight. that, I think Teki also mentioned this as well, that a DPIA, I mean, once you sign off, first of all, you need to make sure that the DPIA is then relevant to to what you were trying to achieve in the first place. So the outcomes of the DPIA needs to be in one way or the other integrated into, the processing that you were setting out to conduct the DPIA for in the first place. So it should not be like a separate document altogether that does not speak to, or they're not leveraged to help understand the actual processing activity. And the other thing is that, although, and I think Teki also shared a template, although there's templates, these templates are really to guide, right? It's really up to each data controller to figure out exactly what will work based on its internal processes. So take an approach that makes sense based on maybe the scale of your processing, how your organization is structured. All of that needs to be taken into account. Otherwise, you end up with a process that is not workable internally. So I think at the very foundation of that is ensuring that you are taking into account what works well and how the organization is structured to then develop what will be relevant for each organization. Yeah, and then finally, to ensure that this doesn't become of course it should be rigorous but not extra time consuming. So in that instance, it's important to ensure that you have documents that sort of guide internally on what the process should be like. So it's easy and it's quick to be able to engage in DPIAs. So that said, I will just very briefly go over how very high level we conduct DPIAs at Meta. Like I mentioned at the start off, to say that this, I mean, is the DPO is really at the center of this conversation and really advises on how the organization conducts DPIAs. And so it's important that the DPO is consulted at the earliest opportunity, as you can imagine, on whether or not, for example, a DPIA should be conducted and how it should be conducted. And so, of course, that then means that the DPO, the ODP, the office of the DPO itself is central to, helping the organization understand what criteria should we take into account to determine whether or not the DPA should be conducted. And ensuring that, the process is followed in the way it has been outlined to be followed. So basically ticking all the boxes and ensuring that they are sort of conducting an independent review of, what are the safeguards, what are the security measures, and all of what is required to essentially address the risks that have been identified. And then, the process is very, very similar to what Teki has shared, but also what, is the guidance has been provided by the ICO. So of course you want to, and of course this will not follow exactly in the order of the ICO or other documents, but you want also to ensure that it's clear who has been involved in the process, right? So who are the relevant staff that have been involved in this process? What is their role and what was their role, generally speaking, but what was their role in particular in the process of completing the DPIA? That you already know how to, if there are questions that needs to be asked, you know who to go to answer the questions. And then you go through all the questions, right? That all the steps that I mentioned earlier. Why do you even need this DPIA? Because it's crucial. You don't do a DPIA for it just for the sake of doing a DPIA, So you look at like how do you identify basically that it indeed qualifies as a high risk kind of processing that then requires a DPIA. How do you arrive at that point? And then you have to go into detail and describe the processing operations and the scope of the processing, what exactly is planned, what kind of data, personal data is going to be processed. Would it involve sensitive or special categories of personal data? How will the data be collected? Whose personal data is going to be processed? And how will that happen? What is the purpose of processing? Again, this you see really it really brings to play like the provisions you see in the data protection law around the principles of data processing and also the legal basis of processing of personal data are really brought to life in terms of when completing a DPIA. So you're thinking about like, why is this data being processed? What's the purpose? And then, also conversations around or considerations around like storage of the data. How long will it be stored? Will it be, and when will it be deleted? Like data controller, like who is the data controller in particular? Will there be transfer of the data elsewhere? Those are all what we find in terms of the steps on why the DPIA, on describing the processing operations and scope of processing. And then you talk about consultations. Again, Teki already alluded to this. Who are those internally that you have had a conversation with to ensure that this, this is a thorough process? Of course, depending on the organization. So for MEDA, for example, there'll be various teams that have a role to play and will be consulted. So it could be from, the product teams, the engineering teams, of course, legal teams, policy teams. Every stakeholder that has a role to play has to have contributed to the process in ensuring that we have a comprehensive DPIA in place. Again, assessing necessity and proportionality of the processing operation. It's really about, making sure it's absolutely necessary to engage in this particular processing. Like, why is this necessary? And it could be for different reasons, to deliver a service, to support innovation, but it must be very clear that it is absolutely necessary to engage in this processing. And of course, you can also share there, even though it's necessary, these are the guardrails that have been put in place, right? You're sticking to the specific purpose of of the processing, allowing if consent is a legal basis, allowing withdrawal of consent, etc. And I'll talk a little bit about that a little later on. And then there also could be reference to like, how are you going to achieve data quality, ensure that the quality of the data is intact. Again, here, some of the responses to this could be around data subject rights, right? Right to access, to correct, to delete, and all of that. Could be ways to ensure that data is of the necessary quality. And of course, the big one is, what is the legal basis for processing in this particular context? And as you know, under the NDPA, there are several legal bases. It could be consent, which is just one. There is performance of a contract. There is a legal obligation, public interest, vital interest, and the like. So there are, in any given instance, multiple legal bases that can be relied upon by a data controller. But of course, some lend themselves more to, depending on the nature of the organization, but also the nature of processing that is happening. So it could be consent, it could be legal, legitimate interest, like I mentioned earlier. But just to emphasize that there are several legal bases, and there's not just one, there are multiple of them. And then, you can also look into measures that, that can be leveraged to contribute to the data subject's rights. So, for example, just to give some examples, some of the tools that we have, if this DPIA, for example, was related to Facebook, you have tools like, access your information. So to be able to understand what kind of information is held about you, you can there's a tool that allows you to download all of that information as well, or to see the information. There's another tool that allows you to download that information. There's also the right to data portability. And there's also ways you can, port your data, right, on Facebook as well. So these are some of the ways you can identify the measures that you're sort of upholding the rights of data subjects in respect to the particular processing. And also questions around, how are you ensuring that this, processing is prioritizing transparency? Of course, a privacy policy is a primary transparency document. So that's one way of that. But on a deeper level, it's also, how do you ensure transparency within the particular, let's say, feature or service in particular? So oftentimes you will see, and this is across the board, you will see like opportunity to sort of learn more about that, particular feature or whatever. So you click on that and have more information about what you can do or what the processing is about. So that's very important in terms of transparency at a high level. This is a privacy policy, but also in the feature or product itself, there has to be some level of transparency to help people to understand, what kind of processing is actually happening. So all that information should be addressed in the DPIA. And also, you know, how are data processors being made to ensure that they're complying with, you know, with the requirements of the NDPA, for example. So what steps is data controller taking to ensure that the processors are actually, you know, doing what they need to do, whether in terms of transparency or other obligations that they hold. And finally, in security assessments, how do you ensure that you've conducted the security assessments as they should be conducted? What questions are you asking? You know, are you identifying the different kind of risks that exist, and are you taking the necessary steps? So, for example, conducting reviews of the privacy review processes, for example, or access, right? Ensuring that access is only granted to those who should have access to particular kinds of information. And once you identify risks, it's also about thinking through what are the mitigations you're going to put in place. So what is the, you know, overall impact of the risk, you know, and all of those information. So once you have the risk identified, it only goes to, like, it's only stands to reason that you then have measures to mitigate that risk at the end of the day. I think my time is up, so I'm just going to stop here and hand it over back to Teki.
Yes, thank you so much, Dr. Shyllon. I have been struggling with this Zoom a bit in the back, so sorry if I kept zooming in and out as well. We're going to open up. I'm sorry, I believe that there were, you are having challenges with the chat. My technical team are telling me this is a new, it's like a new process that Zoom has rolled out. So they're very unfamiliar, and the chat somehow is disabled, and they haven't been able to figure out how to enable it. So I'm sorry about that, but I think we are at the point where we are opening up for questions. Roland, I believe that we should be able to ask, people can ask questions, right? Raise their hands and they're enabled to speak. Is that possible?
Yes, that's possible.
Okay, so if that is possible, then my ask is that we can, if we see someone raise their hands, we're moving to the point of questions now so that we can at least try and respond to some of the questions that people are asking now. So if we can open up so that people can ask, and if you have the opportunity to ask questions, we'll only take a few questions, maybe about 5 to 10, and then depending on the time, and then we can move to the breakout sessions. Once we're done with the questions, we'll come back, try to respond to the questions as well, and then we can move to the breakout room. So Roland, if there are any hands up, for some reason, once I'm sharing my screen, I can't see. And so if you just let me know who is asking questions, you can unmute them, then they can ask their questions. Whilst at it, a few questions also came out on the Q&A, some of which I have answered as well. So you could read the answers there. Dr. Shyllon, I believe there was one question I saw that was meta-specific, so maybe you can respond to that also in the Q&A. And are there any hands, Roland?
Yes, there is a hand from Laran Akimbi.
Okay,
So if
Lauren,
it's around,
yeah, go ahead. Laran, can you unmute yourself and then ask your question?
okay, if Laran isn't ready, we can move on to, okay, there was a hand raised down now. So currently there are no hands, so let's wait for more questions.
Okay, so I will go to some of the Q&A so that we can answer. And there was a question I responded to. Someone was asking should the DPIA differ from the data protection policy in an
The
organization?
chat is now.
Sorry? Should the DPIA differ from data protection policy in an organization? The answer is yes. DPIA is very different from a data protection policy, even though your data protection policy is your overarching data protection policy for the organization. DPIA may be incorporated into it, but the DPIA looks specifically at when, as an organization, you're going to have a DPIA, right? What are the trigger criteria? What are the processes when we identify a DPIA risk, and who will be responsible for responding or addressing those? Dr. Shyllon, do you want to respond to that?
Yeah, I completely agree with you. A a policy is overarching. It explains, let's say, the position of the company on data protection, and like it's inclusive of like do's and don'ts, the approach, the philosophy, how they want to, respond to data protection issues, generally speaking. But DPI is more specific. It's really about high risk processing activities, right? It's very specific. So they are definitely very different topics, but not unrelated, of course.
Okay, I believe there's a difference between a privacy impact assessment and a data protection impact assessment. They are more or less similar. A data protection impact assessment and privacy impact assessment is similar. Please let me know whether you are able to see the chats that is going on, because we have also shared the slides through there. But if the chat is disabled, I don't know whether you're able to see chats from us. Kindly give me a thumbs up if you are able to.
The chat is now enabled.
Okay, so the chat is enabled, so kindly do the introductions in the chat, and then you should be able to see the slides also in the chat. Roland, are we able to, are we saying that of the 200 and almost 300 people here, nobody has questions? You understand everything? Okay, so there's a question. I'm trying to go through the Q&A questions so that we can answer it. When you are risk identifying, how do you determine the risk rating methodology over and above the listed risk? Naturally, the risks you presented are not exhaustive, and I'm curious to know about your insights on defining a risk rating framework or methodology for an organization. So yes, it's important actually to have a risk methodology for an organization, but your risk methodology should not depart from some of the key trigger areas that I have mentioned. And there are, I believe, online, you can find there's so many resources around how to determine risk methodologies and all of that. And it will usually come with some of the screening criteria questions that I asked as well, right? So you need to know, okay, first of all, it's very specific to the organization, because it's going to be determined on what kind of processing generally as an organization do you do. So assuming that as an organization, you only process, let's say, ordinary personal data, right? So maybe just names, maybe some addresses. Let's say the processing is done manually, right? Your risk level is very low within the organization. Assuming that that's very organization, you decide that you're going to maybe add additional set of information, which may include sensitive information about the person. It may include financial data, maybe credit card information and all of that. Suddenly the risk profile will change. So some of the DPIA criteria that I mentioned would help you determine your risk methodology, but it is something that organizations have to conduct their own internal exercises to do. But there are resources that are available online as well to help you, do a risk methodology and then assess that. But the questions, some of the questions and the criteria can help you rate that as well. Dr. Shyllon, do you want to add to that?
Yeah, sure. I completely agree with you that it really would oftentimes likely be guided by the kind of processing that the organization typically or routinely undertakes, right? What kind of data, what kind of processing do they typically undertake? And from there, you would inevitably look at some key things that I mentioned when I was speaking earlier, right? So for example, around say for example, data processing principles. So if it's the kind of data, if it's let's say, yeah, it's the kind of data that you believe that or the kind of processing that you believe that there might be issues around transparency, for example. So that could be a risk to say the processing is not transparent enough, or the data will not be processed in a fair manner, or the question of legal basis. You will process it without a lawful legal basis. So it really would vary depending on the kind of organization and what they routinely process. I think that will be my contribution as well. So there will definitely be no hard and fast rule, but you most likely see a recurring theme just based on the kind of processing that the organization undertakes typically on a day-to-day basis.
Yes, all right. So thank you. So someone asked the question, the difference between privacy impact assessment and data protection impact assessment. I believe we use, from the English point of view, they're supposed to be different, right? But from the technical point of view, we normally use privacy and data protection interchangeably. So to that extent, they are very similar. But if you want to strictly look at what privacy is, then the impact assessment more relates to privacy. But I believe in this context, it's most of the time used interchangeably. If you look at what a typical privacy impact assessment requirements are and what a data protection impact assessment are, there are a lot of similarities between them, yes. Do you want to respond to that?
Yeah, I agree with you. I think it's just sometimes nomenclature or preferences. It's the same way you have people talk about privacy notices and privacy policy. And sometimes, I think even at Meta, we used to call it it used to be called data policy for privacy policy. So sometimes for some different reason, organizations or maybe regulators would use a different terminology. But by and large, I believe it's the same. And if it's not, maybe like there will be some clear guidelines or clarity provided by the relevant regulator. But I think it's typically used interchangeably.
Okay, thank you. Okay, so those that are asking for the slides to be shared, please, is being shared in the chats. ADRH team, if you're not doing that, kindly do that every few minutes, right? So that we can access it. There's a question, is it correct to assume that before you conduct a DPIA, you need to understand the project processing to be able to conduct a DPIA, meaning the conversation goes both ways from the privacy officer to the project team and vice versa? I'm not sure I understand clearly what you mean. If I'm going to hazard a meaning to this, I believe you definitely need to understand the project and the processing. And that is why a DPIA policy is important, because your DPIA policy will determine, what are the risks on which you can then train the key teams or key stuff around what it takes to trigger. Like you people, Meta has a very comprehensive data protection team that cuts across, right? I think maybe throwing more light on how you do this may be useful for that person.
Yeah, thank you very much. So we do, I don't know if my colleague is able to speak. Is Dara in the room? If she can jump in as well. But yeah, we have a very comprehensive process. And like I explained earlier, we kind of have, there's kind of a separation. So we have a DPO team that focuses on Europe, and we have a DPO team that focuses on all other countries. And there is a lot of, I would say, internal documents and guidelines and processes that help us to understand what needs to be done, who in terms of responsibility and the process, and who needs to be, who knows to do what in particular. So yeah, it is very comprehensive. Yeah, that's what I can add. I don't know if Dara wants to jump in as well. If she can, Teki?
I think, yes, I think I see Dara typing an answer, but Dara, you can just
okay.
Yes.
mute
Yeah.
yourself.
Yes. Hi, everyone. I don't know if you can hear me.
Yes, we can hear you. Please go ahead.
Thank you very much. Sorry, I was busy typing an answer. What was the question, please?
How comprehensive is our process in a nutshell?
It's very robust, really robust. We go through several iterations in checking whether a processing activity or anything we do aligns with privacy expectations or the law. So first of all, for any new process, any new product feature, it has to run through what we call a privacy review. It's at the review stage that we determine whether that processing activity is a high risk. And if it's a high risk, it then comes to my team where we run the data protection impact assessment. And we go through all of the steps that Teki talked about earlier. So there's a lot of, Meta has invested very heavily in data protection, and we have over 3,000 professionals that are focused on privacy. I don't know if that answers your question at a very high level.
Yes, I think, Sarah, and thank you. You probably may need to maybe throw a lot more light on also how the teams, because I'm seeing a lot of questions around, okay, what if somebody is difficult to deal with, or they don't understand the issues and all of that. Before you come in, I just want to say that that's why this process has to be integrated into the broader process of any entity, right? So you don't take data protection aside. You don't even just look at data protection just within the compliance and the risk team, but you need to find a way of integrating data protection to all the processes and procedures. So for instance, if procurement or IT is the way to get or buy new IT products, there has to be a trigger there, right? Where you know that IT or procurement team, whenever they are undertaking a procurement, right, for a particular product or service, they know that, okay, when it's IT and it's going to involve processing of personal data, I need to bring the data protection compliance team on board because it triggers this risk. And that's why I was saying that the training that has to be conducted internally needs to fuse into the global outlook or the total outlook of any entity as well. But Dara, you can just come in quickly and react to maybe the people, right? How do you manage the people? What if somebody...
Sorry.
Yeah.
Before she jumps in, I wanted to just reemphasize something she said earlier, and something you just said now, that there is need for training, widespread training. Completely agree with you, so that everybody understands their role in ensuring that you're complying with privacy related requirements. And we do this, of course. We have an annual training where people are not necessarily only people that are working on privacy, right? And we update that training annually, and it's really like a comprehensive process of helping people to understand that. That said, like Dara already mentioned, right, we have a comprehensive privacy review process, and it's as part of that we will determine through that process, oh, this is actually a high risk kind of process. So for every product that is being developed from scratch, or a new feature that is being built into an existing product, it has to undergo the privacy review process. And it's in that process that we'll now discover, oh, actually it's high risk. There needs to be a DPIA conducted. And once that DPIA is conducted, like I said earlier, the outcome is then fed back into that process. So it's not like a standalone thing that you just do for the sake of doing, and then what the outcomes don't have any impact, right? You have to bring that back into the process and see, okay, we've identified this as the key risks, and these are the mitigations that we're going to take to ensure that, you know, those risks are addressed. And then I think, you know, one person not being collaborative, one person not, you know, being a stumbling block really is not something that sort of distorts this, because like I said earlier, we have a whole number of teams performing different functions and processes as part of the privacy review process or as part of a DPIA process. So it's not just one person. So if you have one person, and you know, you also have to be held accountable for what you do, right? That's why even, like I said earlier, in developing a DPIA, it will have the names of each person who was part of that, the role they played, and what, you know, what exact the role they typically play, but the role they also played in terms of that particular DPIA. So it's very easy to identify what role the person has played and what they have done, and to take any necessary action. So not wanting to do a DPIA or not being collaborative or cooperative doesn't stop the engine room from working. There's a lot of, should I say, oversight by multiple teams and multiple stakeholders that doesn't allow one person to be a stumbling block to the entire process, because there's a huge machinery that is dedicated to ensuring that we are and working on our privacy obligations, but also the expectations of users, generally speaking. I don't know if Dara wants to add anything to that, like on a more technical side.
Indeed. Thank you very much, Ololade. I think I understand where this question is coming from, having worked in different companies prior to joining Meta. There's a lot of misconception, especially by product teams and by different departments within a company around our role as data protection officers. There's a misperception that we are a stumbling block, that we are, you know, we're this bureaucratic block that is stopping the project or the process from moving forward. And a lot of people find the DPIA processes to be quite painful, and it is very painful. And if you look at all of the templates that have been put forward by regulators around DPIAs, it's pages and pages and pages. And sometimes you get the sense that you've answered this question previously. Why is it asking you the same question? But what I see, or what has worked, is to get stakeholder buy-in from the get-go. So at the point where a company is appointing its data protection officer, and by the way, that DPO needs to be quite senior up in order to speak directly to the ears of the CEO. So the DPO has to be C-level suite type employee or person. So you need to get stakeholder buy-in, and the messaging needs to come from the top. It needs to be the top, the senior management in the company saying this needs to be signed off before a new project, a new process, before anything is done. So I don't know if that answers the question, because I get a sense that different from Meta, some other companies might struggle to get the right engagement when it comes to a DPIA, because indeed it is a painful process. Thank you.
Thank you so much, Dara. I saw a hand up. Roland, do you still see it? If not, I think I
Yes,
can.
it's still up.
How
So
many?
I'm allowing him to talk, just one.
Okay.
Hello, Chinolo. If you can hear me, you can unmute yourself and ask your question, please. Maybe we could proceed. If he's not speaking, he or she is.
Okay. All right. Okay. Thank you. So there's a question from Shyllon. It says, it's been, okay, now as a vendor to an organization that has its own data protection policy and implementing a product that relies on the organization's data, do I also need to specify a data protection of my own since I'm assuming the role of a data processor? Or is it significant to rely on the policy set by the organization? I believe in this case, if you're working with the organization, then you have to rely on the organization's policy, right? You're not doing this as an independent entity of your own, unless you're processing the data in your own capacity, in which case then you have to also have your own policies around the data. So I'm assuming in this case, you need to clearly distinguish between your data processing role and your data controller roles. I hope that helps as well. Okay, so we will come back to some of these questions. I think this is a good time. We're going to take a 10 minutes break as well, a bathroom break, so you can mute yourselves and then just get some coffee, grab a coffee or tea or water and or juice, and also use the bathroom for a few minutes. We'll come back. I believe the time now is 1:45 p.m. in Nigeria. So we'll come back in 10 minutes. So we'll come back at 1:55, you know, so it's now 1:45. We'll come back at 1:55 and continue. So thank you. We'll come back to you soon. This a bit late, and so you were still in discussion, but we had to bring you back in. I hope everybody is back.
Yes, everyone's back.
Okay, so yeah, we're back again. Can you see my screen? So we had like 10 case studies, one on the hospital, and a hospital that is putting in place an AI implementation system. We had one on a financial institution that is looking at putting in place a loan repayment risk assessment system as well. We have case study 3 that was looking at a government that is thinking about smart city traffic projects. And then we have a bank that is looking to implement an internet banking and mobile application platform. Case study 5 was looking at an online retail company that is trying to implement a new customer data analytics system. We have case study 6 on a hospital, and then case study 7 on an educational institution that was looking to put in place an IT platform that would enable teachers and parents engage. And then case study 8 was looking at a financial services company that was looking at exploring mobile money loan services. Case study 9 was looking at a motor ride hailing service system. And then case study 10 was looking at a SIM card tracking system. So the idea of these case studies was to really put you in a practical scenario situation to make you think about DPIA based on some of the issues that I have raised. And so at this point, I think I want to invite maybe leads of or whoever is going to be able to present on behalf of each group to briefly tell us what they were able to do. I am very mindful of the fact that this is not, the time you had was very short. And I know it took a number of you a bit of time to get wind of the assignment that you needed to do. On a typical day, this assignment itself may take about an hour or so, and you had less than 15 minutes to come up with something. So we just want to hear what you thought the process was and high level, what you were able to do. And it's okay as well if you were not able to get into it, because I'll have the opportunity to speak a bit more to that. So at this point, I just want to invite the team lead for case study 1 to give us like a brief discussion on what they were able to do. You have about 5 minutes to do that.
If you want to speak, kindly click the button to raise your hand.
I think, yes, Kelechi has raised the hand, so I don't know. I believe she's the one that is going to speak on behalf of the group.
Okay, thank you very much. Can you hear me now?
Yes, we can. Please go ahead.
All right. Thank you. So we looked at the case study, the scenario presented, and we looked at the risk activities involved, and we agreed that yes, a DPIA is necessary. The reason being that, first of all, in a medical situation like this, it is expected that sensitive data would be processed. There will innovative technology will be deployed. Then there will be also innovative use of personal data, because you're bringing in machine learning, AI, and all of that. It's not your regular way of processing data in a medical environment. Then we also thought that because the system will be monitoring consistent monitoring of the patients, and then the volume of data that will be processed is going to be large. Then yes, for these reasons we agree that yes, a DPIA is definitely important. Then we talked about the just for want of time, I want to highlight just the risk mitigation criteria that we considered. We talked about the processes of conducting a DPIA, but then we thought that this was very important, and then it's good that we just talked about it. Then because of the nature of the data that we processed, we thought that anonymization of the data would be necessary.
Yes.
I was moderating.
Please mute. Go ahead.
Okay. All right. So we thought that anonymization of the data is going to be necessary, and is going to be helpful in mitigating the risk of trying to match, or a third party trying to match the data that will be collected in the process with the patients. We also talked about testing the AI system for fairness and bias, such that an AI, if it's been trained with certain kinds of data, it's important that it is being tested regularly to ensure that each time is not going to favor a certain kinds of algorithm in the process. Then it is also important that patients are well informed about the use of the AI and the entire process, so that they are well informed of the decision they are going to be make, and then if you need their consent, they are well informed before they give in their consent. Then there should also be human oversight and monitoring, not minding that the AI has been trained and is being is been trained and tested for a couple of times. It's also good that we have human oversight to avoid certain kinds of errors that should have been avoided in the first place. There should also be room for a contingency plan should also be made for emergencies and maybe complaints from patients. And we agree that it is good to set up an incident response team that will be on standby to assist, to respond to patients and then deal with data breaches if it ever happens, or to also monitor the system to ensure that there is no, third-party breaches, and then which will now lead to loss of personal data. Then we talked of access control to ensure that those who have access to the data that will be collated and processed are those who have a need for it, so that you don't have, the data will not be exposed to third parties or to maybe employees of the hospital or other staff who have no need for such data. So I don't know if I've exhausted my time. I still have time to continue.
No, please. I think we can move to the next group.
Okay, all right.
Yes,
all right.
Thank you very much. Case study 2. So those that looked at the financial institution loan management repayment, I don't know who. Martin, are you the one?
Yes, please.
Please go ahead.
Yeah, thank you very much. So the case.
Oh, sorry. Sorry, I think I muted you by mistake. Sorry.
Okay, thank you very much for meeting me. So our group looked at the financial institution loan repayment risk assessment system. The first thing, like we have talked about, the DPIA data protection impact assessment, is to first of all do a pre-qualification check whether this system actually qualifies for a data protection impact assessment to be carried out. And we use this checklist that is found on page 8, slide 8 of the presentation, based on each of the nature of processing, category of data subjects. So for each of the questions, so many of them had a yes answer. For example, was the processing, with the processing, the first one say, will the data be shared with third parties and transferred internationally? Yes, the answer is yes, because a loan system like the banks, they have relationship with what we call them, credit companies, and they also have relationship with other banks that they share information. So your information will be shared with other banks and with the credit companies, so that because that's a preventive, there's a control that have been put by the banks. But for the data protection, what we are looking at is that your data that is being captured is going to be shared with third parties, which you may not be with your consent, but all you know is you have taken a loan. Then the next talk about the categories of data, whether the processing will involve special categories of data. The answer is yes, because in some jurisdictions, like in the US, when they are getting your information, they may find out whether you are black or your race to take the decision whether to even grant you the loan. So they say yes there. Then for the data subjects, whether it has are the data subjects in position where they can easily opt out. They cannot opt out until they have completely repaid their loan or they liquidate it before maturity. So then the purpose and impact. We talk about could the processing result in discrimination, identity or financial loss or reputation harm? Yeah, one, it can result in financial loss, because anytime you fail to repay, you are going to be charged a default penalty, which may not be known to you. So anytime there's money come, what the bank takes first of all is their default penalty, not your repayment. So that will lead to financial loss on your part. Two, it can also lead to reputation harm, because as you default, your credit score will be increasing, and that will make you not to be able to have facilities from other banks per se at the end of the relationship. When with the other one talk about the technology, whether innovative technologies being used, yes, the answer is yes, because from the case study, it says that machine learning is going to be used to make decisions, which is also an innovative technology as at the moment in our country. Then they say under the legal and the regulatory, yes, they say, is the processing explicitly required by law or regulation? The answer is yes, because it is a CBN regulation that banks should have relationship with the credit companies and they share data among themselves in order to make sure that one customer does not take loan from bank A and refuse to pay, go to bank B and take loan. So it's a requirement by law of the government, that's the Apex Bank, which is the Central Bank of Nigeria. I think for so many of them, they say yes, yes, yes. And the idea is that the pre-qualification, whether this system requires a DPIA, so many of these screening questions have a yes answer. And the fact is DPIA will be required. So we are supposed to move to, once we have done the pre-qualification session, that to determine whether a DPIA is going to be carried out for this this system, the next thing is for you to identify the risk associated to those that system. And we're able to identify a few risks. One is unauthorized, in fact, uninformed consent, because a lot of the data they are collecting about you, you are not aware that the extent. So you may, in fact, they may collect more data than you consented them to collect. So that is one risk that is there. The second one is that your data is going to be transferred to third parties without your consent. Because of that one, we said it's going to be shared with other banks together with these credit companies. We also have the fact that the reputation, it is going to lead to reputational risk for the data subject, or any time they fail to repay for one reason or the other, it may not be their own fault. If somebody loses his job, so we cannot repay.
I think you should be wrapping up.
Okay.
So that we can move to the next.
Then the next thing is supposed to be, after you have identified the risk, you rank them with the impact. What would be the impact and the probability of occurrence, the likelihood of occurrence of each of these risks you have identified. We put all of them. Then you suggest control measures to be put in place in order to mitigate those risks you have identified. Having done that, you suggest the time frame for the implementation of the controls you have identified to be put in place to mitigate the risk we have identified. So in a nutshell, what we have identified in our own is that this financial institution loan repayment risk assessment system requires data protection impact assessment. Thank you very much.
Thank you. Thank you. For group 3, am I seeing Bamidele? Are you for group 3? Can you unmute them, please? Please go ahead.
Okay. Please help me confirm if I'm audible.
Yes, you are.
Okay, thank you. So I'll be representing Akuetteh Bamidele. So we did for smart city traffic monitoring project in Lagos State, and deliberated on why, when, and who. So for why, if it will be needing a DPIA, so we were able to come up with some facts considering what we were being taught during the lesson itself. So the first one that we identified, and one of the reasons why we concluded that the process itself would be needing a DPIA was, one, systematic monitoring. So the project involves AI-enabled CCTV cameras that continuously monitor public spaces like traffic flow, predicting congestion patterns. So this level of surveillance requires a DPIA to assess risk to individuals' privacy. So for the second one that we also identify is the use of sensitive and personal data. So because the system itself integrates data from vehicle registration databases, and mobile may include personal information such as the license plates, location history, and driver details. So, and with this, then a DPIA would need to be conducted. For number 3, that we also talked about was automated decision making, and which is also part of what we're being taught. So the AI system is likely making automated decisions about traffic violations, enforcement actions. So DPIA helps assess whether these decisions are fair, transparent, and non-discriminatory. So the fourth one is large-scale data processing. And from the scenario itself, the project collects amounts of data wide area. So with this, a DPIA ensures proper safeguards are in place to prevent misuse, unauthorized access, or breaches. The fifth why is transfer of data and third-party involvement. So we realized that the system integrates multiple data sources, including vehicle registration databases and possibly third-party service providers. So with this, a DPIA evaluates whether data sharing agreements comply with privacy regulations. So for the fifth one, we have potential interference with rights and freedoms. So constant surveillance can impact individuals' rights, including the right to privacy and freedom of movement. So with this, a DPIA ensures that appropriate mitigation measures are in place, such as data minimization and anonymization. We have compliance with data protection laws. So since this is a government-led initiative, it must comply with that of the Nigerians NDPR, which is Nigerian Data Protection Regulation, and for the international standards like the GDPR. So if cross-border data transfer is involved. So, and in conclusion, we conclude that, okay, the DPI is essential to identify risk, ensure compliance, and implement safeguards. So for the who, okay, let me talk about when. So for the when, the DPI needs to be conducted before implementation. So for the who, we have the data controller. In this case, we talked about the government agency or organization responsible for implementing the smart city traffic monitoring project. Thank you.
Thank you very much. Case study 4. Okay, Timothy.
Okay, good afternoon, everyone.
Yeah.
For case study 4, I'll just quickly take us through what we discussed. I'll give it a short period of time. Okay, so basically for case study 4 is for Africa Bank. Our bank is currently planning to implement internet banking platform and mobile application to enhance seamless transaction for clients, right? And we intend to collect personal data, which would include account details, transaction history, and biometric authentication, right? And basically, we did our pre-assessment on the need to conduct the PPIA, and because we are going to be collecting biometric data, which is the sensitive data, we see that there's a need for us to do that, right? And we quickly swung into action, before we even developed the internet banking platform, and we decided to conduct a DPIA. Basically, when we are conducting our DPIA, part of our own system in the bank is that we make consultation during the process of DPIA. And all inclusive. We start from the beginning, we consult all through till we give our outcome, till we have an outcome, right? And we can proceed. So we describe the processing activities, which of course will include logging in by the data subject, and basically also authenticating the login with biometric features. So because of that, we needed to do assessment as to whether or not it is necessary to collect the data that we've set out to collect. And of course, we found out that it is necessary when we discuss with the relevant parties within the bank for the 2FA and for the signing in. We figured that due to the requirement by the CBN risk-based cybersecurity framework, we needed to ensure that there's adequate security, and that's one of the reasons why we were collecting biometric authentication. So based on that, we saw that it was necessary, and the data that we're collecting will be proportionate. Right. Then we went to identify risk, and some of the risks we identify include collection of excessive data due to the fact that the bank has been operating offline and doesn't really have internet presence and whatnot. We figured that the consent methodology that the bank has been using are majorly physical, and now that we are transitioning to online, we need to ensure that consent methodology online is clear enough for us to determine that a customer has been able to give consent using that particular system. It's a risk because if we do not do that as part of the principle of data by design, right, we may be flouting the provision of the law, and also that would be high risk to the right of data subjects, to be able to give consent for the processing of the sensitive personal data. So, and we also identify that there's a risk of unauthorized access, right? Since it's online, it's web internet, it's web application, our customer data may leak and whatnot. And we also prefer measures, right? For the excessive data, we determine that only the data, that's data minimization, only data necessary for that will be used. Biometry, we only take fingerprint biometry to start with. Then privacy by design, of course, to ensure that we work with the technology team we consulted them, we work with them to ensure that our consent methodology is different, is not a signing, because it won't be possible for customer to sign technically from their phone, except they implement a particular signing technology. But instead of doing that, we are just going to use checkbox because the law allows us to checkbox. And for unauthorized access, we are going to, we propose using 2FA, MFA, using OTP in order to mitigate the risk. So we figure that we have measures in place to actually cater for this. We reviewed our privacy policy last week to ensure that we prepare for this ahead, and we're going to have the privacy policy approved before the project is onboarded, right? So those were the things we discussed. And because we have technical organizational measures such as the privacy policy, which requires our employees to, or including the teams that are working on this project, to follow the privacy policy that has been developed in line with the provision of the Nigerian data protection law, right? We believe that the risk has been reduced from high to low, and because of that, we believe that we'll be able to, proceed to develop and implement this internet application. And because of that, as part of our TOM, we are going to have a data protection agreement with the external parties that will work on this project, since they would have access to personal data, and they'll be subject to the same level of compliance that we believe we are subject to. So those are the things we've put in place, and we think that they will reduce the risk and we'll be able to proceed with our data protection activities.
Thank you so much, Timothy. Can we have case 35, Mr. Awi? Can you raise your hand so that we can give you? Okay, Roland, kindly, okay, unmute him. Please unmute yourself, so.
Can you hear me, ma?
Yes, please, thank you.
Good afternoon, ma. Thank you for your session. So our question was about an online retail company, Omo Naija, planning to implement a new customer data analytics system to enhance personalized online marketing strategies in Nigeria. The personal data, including purchase history, browsing behavior, and demographic details. Yes, okay, yes, the personal. So what we did in our session was we tried to take each step on the steps in conducting a DPIA. So we followed the slides that we got, and we started by asking if a DPIA is appropriate. And in answering that question, we considered some of the questions that were highlighted in the data impact assessment screening. And our conclusion was the affirmative that a data protection impact assessment is needed, because they are handling the data of their clients online, and they are employing the use of new technology in handling this data, and there's going to be the use of AI, and there's a possible data breach. So all the pointers flagged to us that yes, we needed to conduct a DPIA. Then we try to describe the process. We try to follow this. Like I said, we follow the steps. So we try to describe the process of how, yes, the people buying online have to input their data. So if we even went as far as talking about the type of information they are going to input, and we concluded that there are going to be some sensitive information such as the age. Name is not so sensitive, but even we talked about the house address of each person and their traits. That's what they buy, what they've been buying in the past and what they buy consistently. So we concluded that yes, those are pointers that show that it is necessary for us to conduct a DPIA. Then we described the process of collection of data by the data subjects. Yes, it is an online process. Then yes, the stakeholder consultation process. We talked about considering we actually merged that with the assessment of the necessity and proportionality, where we talked about the importance of collating this data and processing it for the use of the from Omo Naija, that's the company, the online retail company, versus the interest of the data object. And we could conclude that yes, the data, the risk, at least the foreseeable risk, does not outweigh the necessity of Omo Naija processing that data. So we're like, what our answer was that Omo Naija can actually go ahead with this because it is not too risky. Then we identified the risks. We talked about, well, we talked about, since it is online, there is not necessarily a physical store where they keep the information of the data objects. So we identified the risks that if the data is not going to go out of Omo Naija, if it's not going to go into a third party, if it's not going to go into a third party's possession, then the risk is very, very low compared to when they have to share to the third party. We also mentioned that if they are going to be employing the use of AI, learning machines, it increases the risk because now the data is not only in their possession, but is now susceptible to every other third party platform. Sorry, just
Should be, wrapping up. So yeah.
So we also have.
I was saying 2 minutes to wrap up. Yeah, please go ahead.
So we also asked questions regarding the operation of the online collation process, whether anonymization will be important or whether it's not be important. So we identified it as one of the ways to mitigate the risk. We also talked about building firewalls and encrypting the data. So I think that's the summary of what we talked about in our session. Thank you very much, ma'am.
Thank you so much, Mr. Awe. Group 5, can you just raise your, Group 6, sorry, can you raise your hand, case study 6, and then we will unmute you. Okay, Roland, kindly go ahead.
Hello. Hi, good afternoon. My name is Ololade. Yeah, I'll be speaking on behalf of Group 6, and we are speaking regards to Royal Oak Hospital. And I will just get right into it. Why is a DPIA necessary, or is a DPIA even necessary? We followed the process as we were taught. The first one is to decide if a DPIA is important or is appropriate by going through the screening criteria. And some of the answers in which we decided that, oh, yes, a DPIA is important with regards to the nature of the processing. Does the processing involve, I'm not reading the question because you can all see it on your screen. The processing includes large-scale data collection. So we said yes, because it's anticipated that the EHR is going to involve a large number of people. It's anticipated that the EHR will also grow. So it's not limited to a small number of people. Then the next one in which we said a DPIA is also important is because the processing involves special categories of data, because it involves health record, health history, pretty much everything that has to do with health information which is sensitive personal data. Then with the processing involve a large number of data subjects, that we also said yes. Are the data subjects in a position where they cannot easily opt out? We also said yes, because the hospital is already in existence and it's adopting the EHR, means that it's just transferring the health records from manual records to an electronic record. So it's highly impossible, or it's highly improbable for the data subjects to opt out because they have a continuous history with the hospital. Then we went on to describe the nature of the processing, or describe the processing. And the processing is for electronic health records, in which the data subjects can access their personal data via electronic means, and makes it more seamless for the hospital to render the service, render health services to them. And the scope of the processing includes their health history, ailments, health prescriptions, doctors' diagnosis, tests that has been done, pretty much the entire scope of health records as it relates to your relationship with an hospital. Then the purpose of the processing in this particular case is to enhance the hospital's provision of health services through the electronic health records. And also, just jumping to the necessity and proportionality test, this processing is necessary because to further ensure that the hospital is able to perform in its function of providing seamless health delivery, and also to save time on the part of the data subject. It's the necessary level of processing. Then is it proportional? Based on the proportionality test, we assess the rights of the data subject as against the processing that we seek to carry out, and we said that it's proportional to the processing in terms of the fact that the rights of the data subject do not necessarily outweigh, the processing that is intended, as long as necessary measures are in place to ensure that the rights are adequately protected. For stakeholder consultation processes, the stakeholders involved include the hospital, doctors, nurses, and entire member of staff, and also the data subject. Because the hospital is the one that is adopting the EHR, means that they're not essentially using a third-party provider. So in this case, they're going to be the controller and processor by themselves. So we don't have like a third-party vendor that is coming on board. Then the risks that we identified include access controls. How is access control going to be monitored? Then how is the data going to be protected in terms of security? Then the data is already pseudonymized, so that's one layer of security. But how do we ensure that we conduct regular security audits to ensure that data is well protected, and we are able to flag any possible intrusion that might want to occur or might happen. So those are some of the risks that we identified. And also in terms of system availability, is data going to be always available? Because part of the TIHR is that data should be always available, or the patient data should be always available. So how are we going to ensure that the system is constantly available? And some of the ways that we decided to mitigate that is to implement access controls. We already have pseudonymization in place, so that also helps. Then in case of maybe when we're storing data, when we want to archive it before we finally delete it, we employ encryption methods to protect the data. Then we would also conduct regular security audits and data protection audits. Then employee training, because all members of staff are likely going to have some level of access to the data. So we're going to conduct employee training across board. So that was the process in which we carried out. Then the final process is for us to put an action plan by preparing a DPIA report, and identifying the risks that we have mentioned, and also the procedures that we're going to take, what the organization is going to do, the hospital is going to, how long they will take the training for, and pretty much all the steps that we already mentioned. Then for the last stage, okay, that's my time.
Your time is up. You have a minute to wrap up, so.
All right. Okay, I'm almost done. So for the last stage, which is review post-implementation measure. So we'd also consistently, from time to time, which we would decide within the organization, constantly review that the risks that we have identified have been mitigated by the procedure which we took, and then also to track if there are any new risks that might come up by virtue of using the platform. So that was our process in conducting our DPIA. Thank you.
Thank you so much as well. Group 6, case study, sorry, is it 6 or 7? Case study 7. Can you just raise your hand so that we can bring you on board? Case study 7, who's the one speaking on their behalf? Who was the moderator for that session? Victor. Okay, I see a hand now. Can you please speak to whether you guys were able to do anything or not so that we can move on to the next?
Okay, good afternoon. This is Victor from Group 7. So, after we discussed the case study, we first identify if this case study actually, if the app, that's the parent-teacher engagement platform, actually need to conduct a DPIA. But the fact that they will be processing a large set of data, the fact that they will be processing the sensitive data, that's the data of students, because we want to believe or assume that the students are actually kids, they are children, so there's a need for them to actually conduct this DPIA. As well, we felt if this if eConnect wants to conduct this DPIA, there's a need for them to have there's a need for them to have this the CIA triad in mind. It should be considered. That's the confidentiality, integrity, and availability principle. Because if they'll be sharing the academic records, behavioral reports, attendance of students, it should be able to assure other parents that okay, it should just be between the people having access to this data is just the parents and the child. I mean, other parents who have access to other children's results, and also the availability of the results. If they need the data that has been processed, would it be available, yes or no, and how, and the integrity of the data, like how accurate would the data be? Also, while trying to consider if DPIA is needed, we also talked about, oh, okay, if they're trying to consider this, if they're trying to like build this platform, there's also a need for them to put in all necessary technical measures like the encryption. So other like how is there what's what right now? Okay, are they sure that the data won't be accessed by any other person? So this should be put into consideration as well. So the eConnect should also have privacy by design on their mind once they're trying to like conduct build the website. At every point of developing the platform, it should consider privacy, and I think that's about it. Just to summarize the whole thing in 2 minutes. Thank you very much.
Okay, thank you very much. Can we have whoever was representing Group 8 to raise their hand so that we can elevate you to speak as well? Group 8, I believe is a beam more, yeah. Okay, all right, there we are. Roland, kindly elevate them to speak. Thank you. Please unmute yourself.
All right, good afternoon. Sorry, this is not my actual name. I think there was a mix-up with my link. So, but we were not really able to do much in my team. So we're supposed to look at the case study of mobile money loan service. My name is Bibitayo Uju. So we were able to discuss whether there's a need for DPIA or not before launching this product, Momo Loan. So it's going to be a mobile application that's going to provide money lending services to Nigerians. So part of the thing we look into is whether the data that will be collected via the app is sensitive data or personal data that could warrant whether there is a need for DPIA. Also, we were able to conclude that there is a need for DPIA, although before we reach that conclusion, we stayed long on flogging the matter of whether financial record is a sensitive data or not. So this particular stage is we engaging with our stakeholders, basically the data processing stakeholders within the organization. And we were able to have divergent opinion, although considering the definition of data, considering the definition of sensitive data in the Act, we realize that financial records are not part of sensitive data. Although under the definition section, the Act refers us back to Section 30 of the Act that gives power to the Commission to, when necessary, give directive as to category or informations that can fall under sensitive data. So, but looking at the implication of what financial record the harm unauthorized access to financial record can bring to a data subject, or we also conclude that financial record is a sensitive data. So, and those are the pointers that made us to agree that we need to conduct a DPIA. So basically, that's what we were able to
All right.
discuss.
Thank you. Thank you very much. Thank you very much. Last but one, case study 9. Can you again please raise your hand, and then Roland, we have a hand raised so that you can please unmute yourself and then come on. Thank you.
Am I on? Can you hear me?
Yes, we can. Thank you.
Okay. So we looked at the newly established motor ride hailing service, Okada Ride, that is launching a motorbike app transport business in Nigeria. And it wants to collect and process personal data, including rider, 1 minute, including rider and customer profiles, location tracking, and payment details. So the question was, is there a need for DPIA? And the quick answer was yes. Why? Because there are risks to collecting location data. There are risks to collecting bank details. So in Nigeria, for instance, the incessant kidnapping of people makes it a huge risk to leave someone's location data out there without protection. And then there's also a risk of financial loss or the use of data subject details to defraud someone else. So these risks demand that we protect this personal information appropriately. So question is, how do we mitigate these risks? And we thought about if we can minimize the data we collect, but whether we can minimize the data we collect or not, if we implement anonymization or the various masking techniques out there, we will be able to protect the data. If we ensure that data is encrypted while at rest and while it's in transit moving from one system to the other, so that downstream users can use this information, whether to test the system or to actually implement it. If this information is encrypted, then we are rest assured that if anybody intercepts this information, they won't be able to read it. And if they're not able to read it, then the data subject is appropriately protected. Yeah, so that's what we discussed.
Okay, thank you. Sorry, thank you very much. Last but not the least, case study 10. Please raise your hand and then we can elevate you to speak. Case study 10. I'm not seeing any hand. Roland, do we have any hand raised?
Not yet.
Okay. Can you raise your hands? Am I seeing a comment in the panel?
Hi, good
All right.
afternoon.
Sorry, yeah, please go ahead.
Okay, good afternoon, everyone. I am Muyunwa Jisloba, and I'm representing the group that discussed case study 10. So our case study is a SIM card tracking law. This is a law that was passed by the government requiring mobile operators to develop a system whereby, the mobile operators can track the movement and usage of SIM cards. And for them to be able to track the movements and the usage of those SIM cards, they would have to collect and process the subscriber's data, that is the data subject's information, personal information specifically. And they are the call records, the geolocation data, and the device metadata. So given the sensitivity of the data involved, we're asked to conduct a DPIA, that is data protection impact assessment. And, it has to be in accordance with the law. So just so we don't take too much of your time, we had to follow through with the steps that we have in our slides and that was explained. So we had to follow through with the steps. And the first step says that you should determine if a DPIA is necessary. I mean, this is like just off the top of our head, knowing that sensitive personal information will be collected. We should know that a DPIA is necessary. And using the screening criteria, we've also been able to identify or to determine that the DPIA is necessary. So step 2 is we have to describe the processing. Like I said, it is a sensitive data. It is sensitive information, and they will be used to track, right? Next, we have to describe the scope of the processing. They'll be collecting the scope of processing, basically the type of data. They will be collecting the geolocation data, the device metadata, and call logs, like your call history. So it's like they know who you're talking to at what particular time, at what location you're talking to the person. So this is like serious infringement on your privacy. However, we have to also be able to determine if they have put measures in place to ensure that, all of this information do not get into the wrong hands. The next step is to describe the purpose of processing, and the purpose of processing is already was already highlighted in this question. The purpose is to track the movement and the usage of SIM cards. I mean, in accordance with the law, because it was the government that passed the law. The next step is stakeholders consultation process. So who are the stakeholders involved in this whole thing, in the whole data processing activity? We have the data subjects, right? We have, that is the mobile operators. We have, there's a high possibility that these mobile operators, for them to be able to achieve all of these things, they will need to employ the service of what we call third-party vendors. So we have to be able to run a consultation. Are they going to use any database management system? If they're going to be collecting this kind of information from the data subjects, do they have, are the data subjects aware that they're collecting this information? If they're going to engage the service of maybe a database management system or a tracking software, the people in charge of those systems or those technologies, are they compliant with the law? Will there be any form of transfer of data across the border? Like the law we use here in Nigeria is the Nigeria Data Protection Act. So if there is going to be any form of transfer of data outside of Nigeria, will the whole processing be in alignment with what we have in the law? What is the accessibility like? Who can get access to, these are just very important questions that are needed to be asked, from the perspective of the mobile operators, the people that put the law in place, the government, the third-party vendors, the data subjects. The next step is assess necessity and proportionality. So all of the personal information that they're collecting, are they necessary for the purpose of which, or for the purpose, are they necessary, or are they in proportional with the purpose for which they were collected? The purpose is to track the movement and to track the movement and how, this data subjects are using the SIM cards. So do you need call records to be able to track movements? Do you need geolocation data to be able to achieve this? Do you need the device metadata to be able to achieve this? And yes, they need them to be able to achieve that.
Okay, I think you should be like wrapping up in a few seconds. So
Okay then. Identify the risks. What are the risks involved, like foreseeable risks involved, if any of this information are, if there is any breach whatsoever? There is a very high possibility that there will be impersonation, identity theft, loss of properties, fraud, and all of those. Risk mitigation process, are the information that you collect, are they encrypted? Are there technical measures in place, basically? Do you have it in your privacy policy? Like, the people whose data you're using for this purpose, are they even aware that you're doing this? Do you have training systems in place for your staff members, especially those that have direct access to this information? And, you have to make sure that you're compliant with the law to avoid fines and, penalties and all of those things. Lastly, your action plan. Action plan is ensure that while you're developing this system, or while you're developing the whole process, the whole technology, ensure that privacy is infused into the whole process. Make sure that you review the process of sharing that location. Make sure that the data subjects are involved. Make sure that you also have like a data breach response team. So let's just say something happens eventually and, any of this information gets out. How would you respond to it? What are the steps you're going to take? Make sure that there are also ways you're able to delegate power.
Your
Thank you very
time
much.
is up. So, thank you very much. And thank you everyone for participating in this exercise. If for nothing at all, I think one of the things that you're going to learn from this is the fact that it's going to take, it takes a bit of effort to undertake a DPIA, and that is why DPIAs is not, let's say, a daily action that you undertake on every transaction. That is why it's a high risk, because it comes at a cost. Even putting together your teams, the time and the effort that it takes for organizations to run through all of these involves a lot of time. But the whole idea of the breakout sessions was to really get you to think about some of the things that I had mentioned, I had gone through. So in order to actually help you answer the questions, I'm hoping that, I think we shared the presentation ahead. So those who may have gone through it may have actually seen some of the answers and the steps. And so I saw in the presentation that you had a good idea of the steps and the processes that you needed to go through. So that was all well and good. But in certain situations where people don't have access to the presentations offhand, the idea is to get them to really think about what should I be doing in the light of the presentation. But the first step you have to take is to really look at what is the purpose for the particular activity, whether it's an AI, whether it's an Okada ride, whether it's a banking service, whether it's an online or e-commerce service, you need to think about the purpose for which you're doing that. Why am I undertaking this particular activity? Why am I putting out this particular product? Why am I putting out this particular service? Then you need to look at the data types that will be collected. And here, your focus is on the type of personal data that is going to be collected, right? So is it going to be personal data, ordinary personal data? What is the nature of that ordinary personal data? Is it going to be sensitive or special category personal data? What is the nature of these sensitive or special category data? And then you need to identify who your stakeholders are. And again, for stakeholders, you want to look at both the internal stakeholders, i.e., if it's an organization, the team, various departments that are critical to the process, as well as the external stakeholders will be things like customers or third parties, etc., that will be affected, and also third parties that you may engage as third parties service providers in the case you're in situations where you are deploying services or products that will require the input of these third party service or product providers as well. And so your next step will be really identifying the risk. And I used the AI scenario as that is sometimes one of the changing scenarios to look at some of these issues that we have discussed, right? So if for most of it, you want to look at the data collection and use. So how am I collecting data? How am I going to use it? And you want to look at, is there risk of excessive collection of the data? Will there be transparency around how data is collected and used? Who is collecting the data? What processes are being used to even collect the data? What safeguards are being put in place in the collection and the processing of the data and all of that? So you want to look at your full scope of the data collection and use, i.e. how you're going to use the information as well. You want to look at security that is involved, right, in the process itself. So you're looking at the full length of the data. So data at rest, data in transit, and then processes. So how are you securing the data? What are the risk of exposure, risk of data breaches? What is the risk of exposing medical information, for instance? What is the risk of exposing other forms of sensitive data in the case where medical data or other sensitive data is involved? What is the risk of data breaches, particularly if third parties are involved, right? What kind of access are you giving to who when it comes to the processing of the information? You want to think about data minimization, right? So is there the potential to keep data for longer than necessary? Are you collecting only what you need for the purpose for which you need it? These are all questions that you're going to ask yourself. You also want to look at biases, potential biases, and fairness issues. In the case of AI, for instance, you have to think around, are there any biased decisions that can affect a minority or underrepresented groups because of the AI processing method that you're using? Would it affect a particular group if you're using some other form of automated processing? Is there any other form of bias that can present itself? Would it be a fair way to process the information under the circumstances in situations where you are anonymously collecting information from other sources and the people do not even have the right to correct or change in situations where, for instance, as a bank, in the case we mentioned, where you are assessing their credit worthiness to give them Momo, and you decide that you're going to use other sources of information, how are you assessing the credibility of that information? Would it be a fair use of that information? And these are questions that you need to ask yourself, in order to ensure the right thing is done. You also want to look at transparency and accountability, right? By accountability, you want to ask yourself, and at this point, I think it's important to know that there's an accountability tracker. The ICO has an accountability tracker. If you go to their website, it's an open source document that you can use to help you assess accountability on its own. So that could also help you. But with accountability, you want to make sure that you are well aware of what the requirements of the law is, and you're processing the information in a way that is responsive to the laws as well. By transparency, you're very open and transparent about what the processes are, what it entails, if people are having challenges, where and how they can reach out to you on. Then the third step you want to look at after you've identified your risk are mitigation measures, right? So if you identify risk around collection and use, and maybe you're collecting more information than necessary, then you want to look at how do I restrict the information? How do I only collect what I need? How do I assign proportionality as well? You want to look also at other legitimate forms of processing, including consent. And it's important, I think Dr. Shyllon raised this issue here. A lot of the time we make this mistake of thinking that when it comes to data protection, every processing of information must be based on consent. No, there are other legitimate ways of processing data. Typically, when you go through an accountability process, you are able to identify all the legitimate means by which you as an organization or an entity processes personal data. And so under the data collection and use, you want to also assess that legitimacy, right? Whether or not you have a legitimacy. If the processing is also based on informed consent, then you have to come back and look at procedures and processes to ensure that your consent is informed. And like I always say, where consent is given, consent can be withdrawn. So you need to also take into consideration processes to have that consent withdrawn. And when it is withdrawn, take respective action on that. For security mitigation measures, you want to look at access controls, you want to look at encryption, you want to look at other technology or technical measures that can be put in place. And remember, this need not only be limited to technology, it could even be physical controls and measures, right, that is being put in place, because the personal data protection does not only apply to digital data. It looks at data personal data in all forms. So the security measures as well must think about what other measures you could put in place. It could be locking of safes or providing safes, restricting access to who has access to some of these information and the like. You want to look at data minimization. So you should only keep the data that you need, only keep it for a period that is necessary, delete after, perform regular audits, have a data retention policy, and so forth and so on. For biases and fairness, you want to look at regularly conducting tests in the case of an AI to ensure that the diverse data sets that you identify are correct, and that you eliminate certain biases as well. In any other format, you want to really review and make sure that your processes are not incorporating any form of biases or unfairness to the individuals. We want to look at involving multidisciplinary teams in the development and review process. So the issue of bias and fairness goes sometimes way beyond data protection, right? So you need to think critically about your stakeholders and how you're going to bring them on board to properly help you assess if there is any unfairness and bias. And of course, I spoke in detail about transparency. Provide detailed explanations of your processes, have a robust accountability system or mechanism to be able to ensure that you're doing these things properly. And the fourth step is what I call evaluation of residual risks, right? So what are some of the risks that will continue to flow from there? Document all residual risk in the case of AI, such as algorithmic biases, potential security vulnerabilities, and so forth. You need to think about implementing an ongoing monitoring and regular reviews to address those risks as they arise. So some of the risks may not be, you may maybe eliminate them at the beginning, but it could come up later. So that's why you want to have a mechanism for addressing these residual risks. And then also, in order to do this efficiently, you have to put in place a contingency plan around how you're going to handle incidents. If there are customers involved, for instance, if somebody comes and complains, how are you going to address it? If there's a data breach, how are you going to address it? The whole idea of DPIAs is to help the organization become more or less proactive, right, in its data protection management process as pertain to that particular activity that has been identified as a high-risk activity, which is prone to a DPIA as well. I believe we are about rounding up. We're 5 minutes over time, but I can take one or two questions and then we can call it a day. So if you have a question, please raise your hands. We'll elevate you to ask it, and then I'll come back and we'll take some concluding remarks. Thank you. Any questions? Please raise your hands if you have any. Okay, I see a hand. I see a hand, Roland.
Hello.
Please, yeah.
Hi. Yes, good afternoon. Thank you so much, Ma, for the presentation. Very, very enlightening. I don't know if Dr. Shyllon is still on the call. I have a question. In practical terms, like practically, when you have conducted a DPIA for a product that maybe an idea or a conception that the business has or an organization has, do you ever actually like not launch the product because the DPIA has identified that the product constitutes high risk, and maybe the mitigating measures or measures that you are intending to put in place might not be sufficient? Has there been any kind of case where that has happened? And also, where a DPIA has been conducted and recommendation has been made, how do you typically implement it such that oftentimes we know that the product team is already developing the product as at the time when the data protection team is also conducting a DPIA? I'm talking practically now. So I'm asking that, how do you balance the fact that the product is already probably in the beta stage and a DPIA says that, okay, this is high risk and we need to put in some measures. Then in the case where the measures might not be sufficient to, in terms of the proportionality test or the balancing test, do you ever not launch that product or maybe go back to the drawing board? That's my question. Thank you.
Sorry, thank you very much for the question. I think we need to maybe try to contextualize this, right? Because as Teki said, a DPIA should literally be part of the everyday approach of a data controller. And so it's not necessarily at least in our context, not necessarily that you're launching a brand new product. More often than not, is like maybe a feature of a particular product, right? So I think, it really depends on the context. And for sure, the whole essence is for the DPIA to help you to think through in a very detailed manner what you're doing, in particular, the risks that are identified and mitigating those risks. So I would say, and again, here I'm generalizing because it's not like we have a specific instance we're talking about. The whole essence is to go back, is to look at what the DPIA has come up with and decide how you're going to implement the mitigations that have been identified. But I think the most important thing is to start off, look at adopting the privacy by design approach. If that is the approach that we are adopting, then that means from the very onset, you're having this conversation, you're having a privacy review process so that you haven't gone so far into the process and have to go back to the drawing board. So the whole essence is doing this at the onset, whether it's a product or a feature. And of course, if it's a feature, then at the end of the day, what it then means is that you're going to go back and ensure that you're implementing all the mitigations from the very beginning, right? To ensure that you're able to address whatever the risks are. And again, this is an ongoing process as well. So the more features you're adding, the more you're doing this, of course, if it's high risk, and addressing what the issues are. And so I think, again, because this is very high level, of course, it's very possible not to launch something or to delay until you've taken the measures that are required, right? Or to change course entirely. But fundamentally, the idea is to do this at the very onset. So you haven't gone far, right? And so it's easy to then recalibrate and say, okay, instead of taking this approach, we'll take an alternative approach to take into account what the DPIA has come up with. Yeah, but so because we're speaking in very general terms, I think that's probably the best I can do. So technically speaking, of course, it's possible, but if you're doing this as we do from the onset, then it helps you to go back to the drawing board and make the changes that are necessary to mitigate those risks. And so it's not an issue of not launching that feature or not launching that project, but figuring out how to address the particular risks that are involved. I'm not sure if that satisfies you in terms of my response. Okay, I see in the chat. Thank you.
Thank you, Lola. Any other question? Please raise your hand and ask it. Okay. Go ahead. Kindly unmute yourself and go ahead with your question.
Good afternoon. My name is Tokumbo Smith. The problem we have with DPIA is because the regulation is new. It's supposed to be a policy from the top management. As long as you don't make it a policy within the organization, we'll still continue to have challenges when it comes to product launching new system coming in. And the only way is that the Nigerian Data Protection Commission has a lot to do, in the sense that they have to address the executives. From my own personal exposure and experience, there was a time we were asked to conduct a DPIA for a financial institution. When we got there, actually they gave us 15 minutes, but by the time we started, we ended up with around 55 minutes before, because the MD was there, the directors were there, the board and everything. By the time we were pointing out the implications of what they have been doing, what they should not do, they were so afraid and they were asking a lot of questions. The moment you don't allow the board, their responsibility and the roles and responsibility of the board is to make sure that policies are given, and then the management must make sure they do the right thing. We'll continue to see that product launching and new software buying is very important. There was a time I asked former MD of NIPS, I said, when you want to buy a software, what's the first thing you look at? I'm talking about almost 20 years ago. Said the first thing we look at is security. So until we see DPIA as an internal document that is very important and is very necessary, then we will continue to have problems. So product launching or any new software, there must be a department that will approve before any product launch is being done. That is the only solution. Thank you.
Thank you very much for your comments. Are there any questions? Any questions, if you can raise your hands. Sorry. Is there a hand? I see a hand. Please, Roland, can you elevate the person, and then Khadija, and please unmute yourself and go ahead.
Hi, my name is Khadija. I just wanted to find out at what point do the regulators step in, if at all? Because I imagine that the commission has a role to play things like this. I don't know if
Sorry, I didn't quite hear. You said at what point do
the regulators, so for instance, the commission, the data protection, at what point do they step in? Are they required to come in from time to time, or
do they, just to get clarity, are you talking about them stepping in the DPIA process or requiring a company to undertake a DPIA? Is that a question?
Yes, so requiring a company to take a DPIA for what, a product launch or for an activity.
Okay, so yes, I think maybe I'll just give a brief comment on what happens in other jurisdictions, and then probably the NDPC can come in with what they have. So typically, sometimes, right, a regulator can sanction a DPIA. Maybe when they sense that there's a high risk in a particular activity. This will normally come in when they have maybe audited processes and they've identified some risk and they want to see how the organization is going to make interventions. In some jurisdictions, they also require the regulator to publish some of the high risk activities. But like I said, it's not exhaustive and it's very particular, right? So sometimes regulators may publish by way of their law what areas, or for instance, you might have situations like the GDPR. If you go to the European Commission, there are clear guidelines around when to conduct a DPIA and how as well. So there are situations where the regulator, through the law, mandates when a DPIA should be conducted and how. There are also situations where, for instance, remember I also mentioned that some of your stakeholders under the circumstances could be the regulator. So there may be a situation where you may be looking at a particular risk area, undertaking putting out a new product or service, where you reach out to the regulator and ask them, to maybe review some of your processes and other things. And under some of those situations as well, a regulator could sanction. But who is here from the NDPC that can also respond to it, so that they can have a more direct response? I believe we have some of you on the panel, so if you can just unmute yourself and respond. Is there anybody from the NDPC that wants to speak to this? Okay, I believe they would probably get back to you at the appropriate time. I'll take a last question and then we will fold up for the day. So if there's one last question, I can take it. Okay, there's one hand. Roland, kindly, please unmute yourself and then ask the question. Okay, I think we lost you. Please raise your hand again so that you can unmute yourself. All right, so kindly unmute yourself and then go ahead.
Good afternoon. So this question is for Dr. Shyllon. So I'm just going to ask, from my experience working across different jurisdictions, so I know that from my experience working in Nigeria, oftentimes there's a lot of similarity in data protection legislation across jurisdictions, but sometimes you find some disparity. So what has been the greatest challenge for you, Doctor, working across different jurisdictions, and how have you been able to navigate where there's been that difference in data protection legislation from one jurisdiction to another for your organization?
Thank you very much for the question. So I think I'm not sure if you were here at the beginning, as my colleague mentioned, we have quite a number of folks within Meta that work on privacy, right? So it's not just myself who is in the policy team. So we have legal folks, we have product folks, we have, different teams working on privacy related issues that have a role to play in the whole DPIA process. So that said, I think, as you rightly mentioned, harmonization is one challenge that we face, because the reality is that when there are differences or nuances, and sometimes it might come across as a small difference, it then has implications in terms of how you go about addressing some of the key issues. And so I will say that the way we try to approach it is beyond the obvious requirement of complying with regulation, is to try and set the bar high. And so if you set the bar high, and we're talking generally speaking here, not necessarily about DPIAs, right? If you set the bar high, then it means that because there are similarities, but also minor differences, it then means that you already have a high, shall I say, starting point, and they can then, the reality will then be that you would have been able to sort of, you'll be complying with most of the most important requirements, and then solve for, the nuances because of how different laws have been drafted and the kind of requirements that have been created. If the reverse were the case, then it makes your work so much more difficult, because then you're starting from the minimum, and then you have to start looking for each single law and what the requirements are. But if you start with okay, let's start with the high level of the highest kind of standards that we can apply across the board, and then solve for the nuances that will come up here and there. So that's generally the approach that we take. And so, for example, it doesn't mean that the fact that a country doesn't have a data protection law, that means in that particular country, we are not applying any of the general, for example, principles or even legal basis considerations. You have to have a minimum standard, which should be high, not the barest minimum, and then solve for specifics in individual jurisdictions. So that's the general approach that we take on a high level. But yes, harmonization is always a challenge, not just for Meta, but for other data controllers, especially if it's a global company and you're processing data right across the board. I hope that answers the question.
Okay, thank you so much, Dr. Shyllon. Here are a few resources that could really help you sharpen your skills around how to conduct data protection impact assessment. These are useful resources, but of course, they are not tailored to Nigeria, and so your Nigerian laws, but they are very good and useful tools that can help you shape and develop your own data protection impact assessment processes as well. I think that really brings us to the end of this webinar, and I want to say, use this opportunity to say a very big thank you to the NDPC, to Meta, and then our team at ADRH for really helping do this, make this possible. And I also want to say a big thank you to all the attendees, I still think we have more than 50% of those that joined still here. It's been almost 4 hours of comprehensive engagement here. And I know it's so difficult to do these things online, but thank you so much for joining us and for participating. If you don't yet follow our pages at the Africa Digital Rights Hub, then I would urge you to follow us either on YouTube, on Facebook, on LinkedIn as well. And then also go to our website. We have a lot of resources there. I know a number of people have been asking whether the videos will be put up. I believe at a later stage it will be edited and will be shared on most of our channels and pages that I have mentioned. So please do well to follow us, particularly on LinkedIn, on X, on Facebook, if you don't already do so, and you can get direct access to some of the resources that we have on this. Also, like I said, we're doing this as part of the Data Protection Africa Data Protection Week as well, but we have other engagements that we conduct, other masterclasses that come in every now and then, as well in other areas of data protection, cybersecurity, child online protection, intellectual property rights, and the like. So please do well to follow us on our pages where you can get direct access to it, and also visit our website, because a lot of these resources will be also posted there, and you can go back and review it as well.